All rise.
Please be seated. We'll hear argument in 22-1074, the City of Houston versus Sauls.
May it please the court, Ms. Martin will present argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal.
Good morning. May it please the court. The case that we're about to talk about presents issues of governmental immunity, specifically official immunity and the emergency exception. I know the court has granted the petitions for review in a couple of other cases involving these same issues. So I wanted to start the discussion today with one of the issues that makes this case rather unique among the cases in front of this court's docket, which is how these two interact with each other, which is the third issue we presented in our brief on the merits. In this case, the majority opinion found that there was a fact issue as to the existence of an emergency call. But then when they analyzed official immunity, they applied the Chambers-Wadowitz needs risk assessment, which this court has emphasized only applies in the context of police pursuits and other emergencies. Now, at the time this case was submitted, which was in December of 2021, that was prior to this court's opinions in Maspero and Riojas, that provided additional guidance to the courts of appeals. So this court did not, the 14th court at the time, did not have the benefit of full briefing on those issues. But in March of 2022, once those two opinions were decided, we provided a letter of supplemental authority and explained to the court that these opinions came down and their significance to the issues in this case. Nevertheless, when the court analyzed official immunity, it applied the more rigorous Chambers-Wadowitz need risk assessment. Now, the dissenting opinion flagged the issue for us and said, assuming that the need risk assessment applies, I would say that the City of Houston met its burden to present evidence of the needs and the risks. And then the issue became, under Riojas, how can that be? How can a court apply the more rigorous Chambers-Wadowitz needs risk assessment while simultaneously finding a fact issue as to the existence of an emergency? Under Riojas, I don't think that can happen. And so we really have to do a gut check with the courts now and say, all right, once a court reaches a point where it has decided there is either no emergency at all or a fact issue as to the existence of an emergency, there has to be a step back on the official immunity piece. What test are we going to use to evaluate an officer's good faith? It cannot be the more rigorous Chambers-Wadowitz needs risk assessment.
How would a post hoc analysis of the needs and the risk ever be the way to decide whether somebody in the past acted in good faith?
I agree. It may not be. And so I think this court has emphasized this is an abuse of discretion standard. And so we don't need to look back post hoc and nitpick what the officer did. The court just wants to see that the officer gave some thought to the needs and the risks of their actions. Did they do an analysis at all? And if they did, great. That's what the court needs to see.
Like an awfully sort of, I think the way you stated it is what is in the case law. And my question is just, does it, practically speaking, does it make any sense to ask whether an officer in an emergency situation performed an analysis? Like, balance the needs and the risks in the way that we now as lawyers and judges sit around with hours and hours to think about it, balancing these things, and then project back and ask whether the officer engaged in that kind of analysis in the heat of a moment with all kinds of things racing through his mind. It's a bizarre construct, as far as I can tell.
Yes, and it does lend itself to what the dissent called Monday morning quarterbacking in a way. You know, what the benefit of hindsight that overwhelmingly lends itself to things that the officer could have, would have, should have done. And, you know, in this case in particular.
So is the answer just there should be immunity? Always?
Speaking as a governmental unit, yes, I would like.
Okay. Assume we're not with you on that. What?
Not necessarily. You know, the test for good faith this has been one going back to, 1997 in chambers. This is the test that's always been there. So if we're going to look back okay, so that's, quick math is not my strong suit. So we're going back nearly 30 years of precedent to come up with a new construct for how are we going to judge good faith. And if we're going to do it with something other than the Chambers-Wadowitz needs risk assessment, maybe we replace all of it with Telforster. A reasonably prudent person could have believed his actions were justified.
What about the evidence that it took 24 minutes for the accident to happen, and that the standard procedure required a 5-minute response in an emergency? Isn't that some evidence of something?
Well, it's could be evidence of multiple things, which is why it's probably not evidence of anything under the equal inference rule. It could be evidence that City of Houston was understaffed that night. That shift had a lot of calls and not enough officers to respond to calls. It could be evidence that the 5-minute that's a goal. That Q standard is a goal, and we don't always get there. It could also be evidence that the Q standard wasn't followed and there was a policy violation. But a policy violation doesn't necessarily negate good faith.
But couldn't it also be, construed to be that for whatever reason that this person had called in multiple times claiming that he was going to kill himself, and that therefore the person didn't think it was an emergency?
Well, let's take a step back on that. We don't necessarily consider those things when we're judging good faith. We consider what the officer knew at the time. And if the officer didn't know at the time that the Q standard had been holding for more than 10 minutes, if the officer didn't know at the time that the person had called in on multiple occasions, if these are things that plaintiff's expert, former Officer White, put in his affidavit that are not consistent with what this court has always said the courts should consider. The official immunity analysis should be limited to what the officer knew at the time. We don't go outside of that.
It just seems that may create a fact issue.
On whether there was an emergency.
On whether there was an emergency, not if we're separating emergency situation and emergency call as the statute is written. Because again, it's in the disjunctive. 101.055 says this statute does not apply to the actions of an employee when responding to an emergency call or reacting to an emergency situation. We have to read that or. And I know the arguments earlier talked about and or quite a bit. In our situation, it's or. So we have two cases previously out of the 14th Court of Appeals that talked about this. You can go to an emergency call where there is no actually an emergency situation. You're still on an emergency call and you still get the benefit of the exception.
So let's say if a teenager calls and makes a prank call to the police department or 911, whatever, and says this is an emergency, do blah, blah, blah. And it's very clear that this is a prank call, but it's reported as an emergency. So you're saying that your argument still prevails?
Absolutely. And the evidence in the record supports that. Officer Starter testified that when a patrol officer receives a call from dispatch, if it is dispatched as a priority two, let's say the teenager prank called a suicide in progress like this was, patrol officers don't get the judgment to unilaterally say, oh, it's just a teenager, it must not be an emergency, and disregard that unilaterally. If it's dispatched as a priority, they have to treat it as such.
Will you go back to where you started and finish? I think you were saying that under Riojas and that the needs risk assessment only applies if there was an emergency. And so therefore, if there is a fact issue on whether there was an emergency, then you can't apply the needs risk assessment. I think that's what I heard you say earlier. If that's what I heard you say, then the question then is, then what does the court do? Because if there's a fact issue, decision tree, emergency, yes or no. Yes, apply the assessment. No, do something else, which you didn't get to. But if we don't know which one, then what's the court supposed to do in that circumstance if the court concludes there's a fact issue on emergency?
So as I understood Riojas, Telforster is that authority. Telforster, if we don't know whether there's an emergency or not, we have to step back, because the Telforster standard applies anytime there's any situation of good faith other than a police pursuit or other emergency. So if the court is, I don't know if there's an emergency or not, we take a step back, and Telforster is what the court has to use to evaluate official immunity.
So
Don't
we,
we ha-
go ahead.
I mean, don't we have to take Hewitt at his word when he testifies that the dispatch did tell him the call had been waiting, and so his response was not, oh, this is not an emergency. His response was, so it was very urgent in my mind because time had elapsed.
Yes, we do.
And so if,
Who else would be deciding whether, what other evidence should we consider about whether this constitutes an emergency other than this firsthand evidence?
Yeah, so we can consider Detective Starter as well. He was with the Accident Reconstruction Unit. He provided valuable evidence as to this being a Code 2. A Code 2 is considered an emergency call, and Hewitt couldn't disregard that.
but we can also consider his actions, right? Hewitt's actions, stopping at the stoplight and so forth, not turning on his emergency lights,
In considering whether there was
whether it was an emergency.
So if you're considering whether there was an emergency situation, maybe. But again, if you're talking about whether there is an emergency call, the court need only look at three things. One, what was it dispatched as? And two, whether that dispatch call is considered a priority or an emergency call under HPD's guidelines. And that evidence is unrefuted.
How does that difference between emergency situation and emergency call map onto the need risk assessment? So if, for example, if we were to agree with you that there was an emergency call here, then the emergency exception would apply and we'd never get to the official immunity inquiry about needs, risk, all of that. And so is your position that that's basic, there's really no need for official immunity anymore in an emergency situation? You never get to that issue.
Not necessarily. It's, some cases lend themselves more to an official immunity analysis, and some cases lend themselves more to an emergency.
But I thought you were just saying we have to decide whether it's an emergency or not in order to know what official immunity analysis to conduct, because we have to know whether to do it under Teltorster or
Yes.
under the needs risk balancing. So
Yes.
basically you're saying just kind of shell official immunity. You can't go there first. You've always got to start with the issue of emergency now.
Not necessarily. And there are some cases, it's official immunity applies in non-emergency contexts too, let's be clear. And there are some situations where official immunity may be relevant, and even if there's some question as to maybe there is or maybe there isn't an emergency, it might be easier for a court to analyze a discretionary function outside the context of an emergency. So let's say, it's well settled.
But you have to know whether it's an emergency or not to know how to analyze that.
Yes. And so what the court can do is say, let's assume, like the dissent did in this case, let's assume that this was emergency for the purposes. Telthorster is met, and if Telthorster or Chambers-Wadowitz needs risk assessment is met here, and if that's met, the less rigorous analysis is easily met too. So a court can assume without deciding under official immunity without going into the emergency exception. I would still consider official immunity a valuable tool, and I wouldn't shelve it because some cases lend themselves more to that analysis.
Let me ask you about the needs risk assessment. So we've said that of course, this affidavit is not prepared in the heat of the pursuit. The officer gets to sit down and think about what he wants or she wants to put in it. And we've said for that reason, you have to identify and discuss the availability of alternatives. And you also have to identify what the risks are. So why isn't it a problem under the need risk analysis that the affidavit doesn't identify the risk of Officer Hewitt looking away from the road to activate his body camera while he was going 66 miles an hour on a dark street?
Okay, may I finish? I'm out of
Yes,
time. Thank
you
you. First of all, there is no record evidence that he looked away. There's just none. The body-worn
Well,
camera
his officer,
footage.
could we assume that from the fact that the other person in the car saw the bicyclist in time to warn the officer and say, watch this guy 3 times before he hit him?
No, we cannot assume that from the record. That's not part of the record. There is nothing that says our officer looked away from the road. The only thing we can say is that he turned on his body-worn camera footage at some point. There is no
Well, we
evidence
know
that he
exactly
looked
when
down.
he did it, right?
Yes.
Because it started recording. It's not just at some point.
Yes, but he didn't necessarily look down to do it. That's what we know. Because the footage does not show their eyes or faces. You see an arm. That's it. And so the screenshots are in the record, I think at pages 211 and 215.
And what about needing to identify and discuss the availability of alternatives? Wouldn't it have been an alternative for him to use the lights and the siren at a certain time, before getting to where he was going?
So he implicitly rejected the alternatives of using lights and sirens at all. The idea of him using lights and sirens at some point along the way came from White. The fact that the court interpreted and adopted White's analysis into its opinion without even thinking about...
Why would you even need White to know that that's an option? Obviously, that's an option.
Well, an option. Hewitt didn't have to consider an option, that option. He had other options that he thought about.
To warn people on a dark street that he was going 66 miles an hour?
He implicitly discounted that because of the public safety need for the person he was going to. Again, this was a suicide in progress.
So if all of that can be done implicitly, then what's the value of the needs risk balancing?
From this court's opinions, to ensure that an officer isn't just pro forma going into a situation, that they're actually giving this some thought.
And is which of our cases talks about being able to implicitly discount things?
Bonilla, Clark, and I think Tuarte, which was a per curiam, it's a good one for talking about how the needs risk, the court standard has never been consideration of all needs and all risks. You just have to show that you've considered some.
Any other questions? Thank you, counsel. We'll hear from the respondent.
May it please the court, Ms. Bryant will present argument for the respondents.
Good morning. May it please the court. I plan to focus my comments on what the Court of Appeals opinion, its holdings in the opinion, and the evidence that they relied on for those holdings. But briefly, I will address, before jumping in, the notion of need risk analysis and whether it should be applied in this case. That was the standard that was argued in the trial court, in the Court of Appeals, and is just being raised here. It hasn't been addressed in either of those courts previously. It's a new argument, and it was waived by not being brought up earlier. Furthermore, going back to whether or not there's a fact issue as to whether or not there was an emergency. And so the idea there that you could just go ahead and apply the lower standard when you do have a fact issue, then would open up the possibility that you're applying a lower standard, and then later it turns out, the fact issue is resolved and there was an emergency and you've applied the wrong standard.
But if the fact issue is resolved and there is an emergency, then the exception applies and there's immunity, right?
Potentially, yes. Well, most likely, yes. So I guess that.
Trying to figure out how
You're
these
right.
tests fit together.
I know, me too, to be honest with you. But more importantly here, the purpose for the need risk analysis that's been reiterated over and over is where you have an inherently danger to bystanders because of speeding. And even if there was an emergency, you definitely have that here. It's undisputed that Officer Hewitt was going 22 miles per hour over the speed limit. And that's been reiterated in both Telforster and in Rios as the basis. So it's not black and white, whether or not there's an emergency or not. I think it's for the purpose of the test is there a need to protect bystanders, and especially when you have the speeding issue, which is undisputed.
Where was the bicycle, like relative to the traffic and the lanes?
The bicycle?
Yeah.
It was in the median. It was about to cross the road. This is my understanding from the record. And Officer Hewitt was in the lane closest to the median. Is that?
And then the bicycle came out into the lane as he was approaching?
That's. I think he was starting to come out into the lane as the officer, was speeding without his lights on.
Perpendicular to the police car, the bike comes out into the lane in front of him?
The evidence at this was the record here was very early in the case, before discovery had been developed. So I'm not sure it's 100% clear from the record here.
I couldn't find a diagram or anything, but was the bike so the bike was crossing the road though, not proceeding the same way the police car was?
That is my understanding. Yes,
Okay.
They were going in. Yes, there was a T.
Right. And so was the bike in a crosswalk, or do we know? We don't know.
The record is very early. This motion for summary judgment was filed months before the end of the discovery deadline. In fact, Officer Hewitt hadn't even been deposed at the time that this was filed, so I don't know much more than that. But I will, going back.
Do we know what street it was on?
The bicyclist or the driver?
The driver.
It was North Wayside, is what the record says. Going back to, I'll briefly address the emergency response exception. The Court of Appeals determined that there was a fact issue as to whether Officer Hewitt was responding to an emergency call based off of Officer Hewitt, Sartor, and the call log. The city seems to take the position that it's unrefuted that it was an emergency call because it was a priority to call, and that's based off of Officer Hewitt and Officer Sartor's testimony. But that testimony is hardly without contradiction or inconsistencies, as the Court of Appeals points out. And including, the timeline. They weren't following the timeline that's required for a priority to call. Priority to call.
The city says in response to that, yes, but that just goes to whether they were treating it as an emergency situation, not an emergency call, and that those are different things. What's your response to that?
I think it definitely goes to creating a fact issue as to whether or not it actually been designated as a priority to call. And that's determined by not Officer Hewitt or Officer Sartor, but by dispatch. And there's ample evidence that contradicts the notion that it was classified as a priority to call. Furthermore, even if that's clear in the record, but also how it was treated as a priority to call, whether it was treated by Officer Hewitt and dispatch as a priority to call, should control, really. Because otherwise, just by classifying as a priority to call, puts classification over form over substance.
Could there have been a reason the legislature divided those two out in the sense that they want dispatch to triage the calls, and then once dispatch does and decides that a call is an emergency, we want to do everything to ensure that it's treated as an emergency. And it seems like if we then examine whether it's treated as an emergency to decide whether it's an emergency, we're backing off of that. And it could be that the legislature said, no, we don't want emergency calls to languish. And we want to affect that policy by saying that they're emergencies.
Well, it doesn't say in the statute priority to call for sure. It says an emergency call. And so,
But responding to a suicide in progress, would that be, if you were going to triage calls, would that be a reasonable triage to put that in as an emergency call?
potentially, and the record makes that clear, that when they triage calls, it really depends on not just whether it's a suicide, but also that they could have additional information. And additional information here, the record shows, did develop, that there was evidence that it wasn't a suicide, that it was, that really the patient just wanted to be transferred to Ben Taub Hospital in Houston, and that there was an emergency situation. So I do think, first of all, just because it's initially classified potentially as an emergency call doesn't mean that that's dispositive, because there's also circumstances could change. So I don't think
you're saying that courts should look and say whether or not it truly fits the bill of an emergency, and then also whether it was treated as an emergency. Those are two things we should look at in addition to whether the dispatch characterized it as one.
Yes, and I think that goes to the purpose of the statute too, which is to balance, the protecting the public versus the need for a prompt response. And if there's no need for a prompt response, then that, counts against, needing to the protections that's there in the statute to officers responding to an emergency call.
Do you think one of the purposes of the statute is to avoid disincentivizing police officers from worrying about negligence liability during situations that are emergencies? You don't want them to be reacting timidly in fear of liability during an emergency. Would you agree that that's part of why this is here?
Excuse me, sorry, I didn't mean to. That's definitely one of the in the case law has been identified as one of the policy considerations for this statute, as well as for the need risk analysis. But there's also the countervailing policy of needing to protect the public at the same time. So they both need to be balanced.
Isn't the role of the police department or maybe the city to draw a line and define, maybe in policy or some kind of training manual, whether, say, for example, it constitutes an emergency that there's been a call about shoplifting? I mean, they seem better positioned to do that, and in fact, they have guardrails around what can and cannot constitute an emergency. What document is that?
I'm not sure I completely understand your question. Yeah. I think there's some evidence in the record about the city of Houston does have a policy record for describing priority 1, priority 2 calls, but that's not in the record, and I think that answers your question.
Well, I mean, why? I guess I'm asking why courts should go behind that. It's a similar question to what we heard already, is why, if the city, with its expertise and its training in law enforcement, has gone to the trouble of defining what kinds of situations constitute emergencies, why doesn't that control?
Well, because it's not static, for one thing, and it's also in dispute here whether or not there was an actual emergency and whether it was an emergency call. And just if you make it a static analysis of the city just labeled an emergency, then you don't have the protections of, well, first of all, then why does the court need to look at anything if it's just going to go off of what the city does? So there's a purpose for review and analysis.
Except that then the officer doesn't know at the time whether he's protected by this heightened liability rule. He's got to wait till later to figure out whether there actually was the emergency that was called in, and he doesn't know at the time he's acting whether, like, what liability standard he's operating under, if it's a post hoc analysis of what was really going on.
I don't think it's a heightened liability standard. It's whether or not there's immunity, and
Well, it's conscious indifference or reckless disregard, right? So that's the standard if there's an emergency, and then it's that there's a lower standard if it's not. But if you look back later to decide whether there actually was an emergency, if that's how we decide whether there was an emergency, is in hindsight at the actual, what were the actual facts as opposed to what was the state of mind of the officer, then the officer at the time never knows what standard he's governed by.
I mean, I think the officer at the time knows whether or not he's.
If it's called in as an emergency and it's presented to him as an emergency, but it might turn out later that it wasn't, and the court's going to say he wasn't protected by this statute, then he doesn't know at the time that he's acting what the rules are.
Well, the record shows that they knew it might not have, that it wasn't an emergency, that's in dispute, that there's been a fact issue raised as to that. And I don't think it's, post hoc analysis that I'm sorry, I don't fully understand your question, because it's partly then I don't understand what analysis would be applied if it's, you need to have this kind of look back and evaluation as to whether or not it was a priority to call and whether or not it was an emergency, to know, because there should be a check. And there's,
I guess because what hinges on that inquiry is the liability standard that's going to be applied to the conduct of the police officer, it seems natural to me that you would judge the question of whether an emergency existed from the perspective of the police officer, not from a post hoc omniscient perspective that he couldn't have understood at the time he was acting.
I mean, I think then what you're saying is that we have to take the officers at his, after the fact word too. So there's also that post hoc.
Well, I mean, there's an emergency call, is what the statute says, which signals to the police officer that there's, at least somebody thinks there is an emergency, and then triggers this liability standard here.
Well, and I guess partly the answer to that is going back to that there's a fact issue as to whether or not it was an emergency call. They've testified, Officer Hewitt and Sarter testified that it was an emergency call, but it wasn't. There's facts refuting that whether or not it actually was a priority to call that the Court of Appeals lays out, raising a fact issue on that.
But does that raise a fact issue on whether it was a priority to call or whether the officer was treating it as an emergency situation?
Yes, and I would say yes. It creates a fact issue as to whether or not it was a priority to call.
It just seems like you would only need to look at the text of the call that came in and the policy of the city of Houston to know whether it was a priority to call or not. Is there nothing in that? I mean, I'm having trouble reading some of the stuff in here because it's abbreviations and things, but does it indicate in there priority to somehow?
Not that I'm aware of. It does not, the call log. I do want to briefly address the official immunity defense.
On that, former Officer White says in his report, review of the body cam footage by Officer Curtis indicates that Officer Hewitt was not watching the road immediately prior to the crash, but instead appeared to be turning on his own body camera. Is there body cam footage from Officer Curtis in the record?
I don't believe so.
So this is just Mr. White saying what he saw when he reviewed Officer Curtis's body cam footage.
I believe
Curtis was the passenger, right?
Yes, he's the other officer, yes. But also relevant to the official immunity defense, that whether or not there's a fact issue there, that didn't get reached by the Court of Appeals. And so,
But if we disagree with what the Court of Appeals did say, that might be something we would need to consider as far as whether whether the driver was or wasn't watching the road, and whether his affidavit accounts for that risk.
that would be, I would suggest you would need to remand back to the Court of Appeals on that. There would be that would be your customary practice, is to remand for the Court of Appeals to decide that. The Court of Appeals decided the official immunity defense determined that the city had not met its burden of proof, and so it didn't get to the fact issue part of it. And the city did not meet its burden of proof. The Court of Appeals lays out two grounds for that. The first being that it didn't provide conclusive, and they're supposed to provide conclusive proof of that that the officer had assessed an alternative course of action to achieve a comparable result. And there, in the chase cases before the courts looked at whether or not there was an alternative to apprehending rather than chasing, and has found that when they identify alternatives to apprehending, for example, in Bonilla, the officer was unable to call in the license plate number before he pursued the driver through a red light and hit the plaintiff. And the court determined that that was sufficient, that testimony. In a response case, the Wadowitz case, the court looked to whether the officer had provided an alternative method for responding. And there, the officer was responding to a theft. He testified to viable alternative routes and why he selected the route that he did. Here, Officer Hewitt doesn't identify any alternatives. I didn't hear the city actually identify any alternatives that the officer mentioned when discussing it or in the briefing. They claim that he implicitly ruled out alternatives, but they don't explain how, other than that he was responding to an emergency. But that's the same type of testimony that was in Inier, which was a companion case discussed in the Clark case, where there the officer testified that he pursued the driver because he thought the driver was reckless and there was an urgency to it. And the court there ruled that that wasn't sufficient. He didn't address alternatives. All he addressed was that there was a serious and immediate need for action only, and that wasn't met. And it's important, the courts recognize that it's important for officers to identify alternatives. And Clark really goes into that in particular, explaining requiring officers to assess alternatives ensures that public safety is not thrown to the winds in the heat of a chase. So part of this, going back to kind of the public policy for both of these issues, is there is a need to have a check on officers, and not just, as previously mentioned, there's immunity in every case. Additionally, the court ruled that the city had not met the second prong of the test, the need to balance the degree, likelihood, and obviousness of the harm. There, they rely on the fact that Officer Hewitt very generally testifies in his affidavit that there was traffic was light, the weather was clear, and the road was dry. But it's not at all specific. You don't know when in the time frame of the travel that he's talking about. And the court's been very clear that you need to have fact-specific testimony. And they also suggest and rely on Clark for that. Clark, there was a chase case where the officers were chasing. Anyways, they identified those similar conditions, actually in greater detail, and said that was sufficient for that case, but those were mitigating conditions to the risk of hitting a bystander. In addition to identifying mitigating conditions, Officer Hewitt adds that he was speeding, he didn't have his lights on, and there was bad lighting and an obstructed view. So just merely mentioning those factors that increase the risk isn't sufficient to address and balance the need versus the risk. And that's clear in Wadowitz, where the officer also failed to address the risk of the blind spot that he was entering into. And more importantly, he doesn't address the crucial, issue, which is not having his lights on and speeding. Officer Sarter testified that more likely than not, if he had had his lights on, the accident wouldn't have happened, and that's at CR 61. And his failure to weigh that and weigh whether or not he had the lights on at that time is why there is not this deficiency, and they didn't meet the second prong of the test.
Your time has expired, Ms. Bryant. Are there any other questions?
I just ask one thing,
Yes,
think about the colloquy you had with Justice Blacklock. Can you tell me what the position would be if a call came in to the dispatch headquarters and it clearly was not an emergency, just a routine call, but the dispatcher botched it and called out emergency call to unit 510, whatever? Do we treat that for purpose of the statute as responding to an emergency call or not?
So that's why you need to look at it and not just base it off of, it depends on
What perspective do we measure that from? Do we measure that from the perspective of the dispatcher who received what was clearly not an emergency call, or do we measure it from the perspective of the officers in the patrol car who heard from the dispatcher it's an emergency call?
I think you do measure it from the perspective of the officers.
Okay, that's all I needed to know. Thank you.
Anybody else? Thanks, Ms. Bryant. Ms. Martin, you have 5 minutes.
So, Ms. Martin, I found that where it talks about in the record that he was not watching the road in Mr. White's affidavit, saying that comes from the body cam footage of Officer Curtis. Could you address that?
Yes, so the body cam footage is not in the record. This is White testifying as to evidence that is not in the record. We objected to that as violating the best evidence rule. And that's why we provided the screen captures of the clips of the moments before the accident from both Officer Curtis and Officer Hewitt, because you cannot see their eyes or faces. Officer Curtis is sitting, from those pictures that are in the record, is sitting parallel. You do not see Officer Hewitt's eyes or where he is looking or his head. You can't see any of that. The perspective is too limited. So White, you just have to base it on his perception of what he saw from the body-worn camera, which isn't in evidence itself, versus the screen captures that reflect you can't see any of that. I did want to address two questions that the judges had earlier. Where was the bicycle? So Dwayne Foreman was at a cross street on Wayside. And that cross street, he started over on this side over here, and he had a stop sign. And that stop sign was supposed to govern his travel all the way across the, I think it was eastbound and westbound lanes. He stopped, but he did not yield to the traffic that was coming, which was Officer Hewitt and Officer Curtis. That was his responsibility because he had the stop sign. And so when we look at Officer Sarter's testimony that plaintiffs themselves, Ms. Sauls provided, they offered Officer Sarter's testimony. We have him saying that even if Officer Hewitt had been going 40 miles an hour instead of 62, the accident still would have occurred. And what we have is a failure to negate or failure to provide a causal nexus for the allegedly reckless or illegal action that would negate application of the emergency exception here. And that is plaintiff's burden of proof, which this court has recently reemphasized in Maspero and in Rattray. So the second question the court had, I think it was Justice Huddle, the policies from the Houston Police Department regarding response management. This is in the Houston Police General Order 600-01. It's available on the Houston Police Department website. The court can take judicial notice, though the version has changed since this case was instituted. And among the changes, there is now a Category E But there is still categories 1 and 2, and category 2 is described the same way as it was at the time, potential threat of harm to an individual. And there was testimony from Officer Sarter that this was dispatched as a suicide in progress. You have an individual who was described to Officer Hewitt to be someone who is trying to harm themselves or others. I mean, again, in Maspero, the court described how we have to tread lightly. We want to leave to officers to make reasoned decisions about balancing the public good from the people they're trying to save versus the other people on the road. And when you have a suicide in progress, you never know what you're walking into. And if we have the Court of Appeals opinion, which posits that a person isn't that suicidal unless they already have a knife to their throat, that's bad policy. We need to make sure that officers who are dispatched to a Code 2 are free to trust that they are protected for a rapid response to try to save lives, which is what they're trained to do. If the court has no further questions, I'll yield the rest of my time.
Any other questions? Thank you, Ms. Bryant. Ms. Barton, I'm sorry. The case is submitted and the court will take another brief recess.
All rise.